Let's talk about an advertisement that isn't really an advertisement. Imagine you are a tobacco company. The government tells you that you cannot advertise your tobacco products. So you stop showing the tobacco products, but then you launch Elaichi. You put the same brand name on it and you give the advertisement to Shah Rukh Khan, then Ajay Devgn, then Shroff. You spend millions making the brand famous and technically you are advertising Elaichi. But is this legal? Or are you simply advertising the product that you are not allowed to advertise without showing it? This is exactly the question at the heart of a controversy that has now brought Shah Rukh Khan, Ajay Devgn and Shroff under the scanner of Maharashtra's Food and Drug Administration.
This comes after the Maharashtra Food and Drug Administration issued notices to Bollywood stars Ajay Devgn, Shah Rukh Khan and Shroff over a Vimal Elaichi advertisement.
Now the Maharashtra FDA has issued show cause notices over advertisements for Vimal Elaichi, alleging that this amounts to surrogate advertising of a Vimal Pan Masala. Now the actors have been asked to explain the rule, and the regulator has also sought removal of promotional materials from the social media platforms. But here's the interesting part. This isn't really about a story about three Bollywood stars or actors. It is a story about something much bigger. Can advertising regulation keep up with the creativity of advertisers? And to answer that, we need to understand how India built its entire system of regulating tobacco, pan masala, and celebrity endorsements. Now let's start with the simplest definition. Surrogate advertising is essentially a strategy in which a product whose advertising is prohibited or restricted is promoted indirectly by advertising another product or service, often using the same or closely associated brand identity. Think of it this way. Product A, advertising is prohibited. So the company promotes product B. Product B carries the same brand, similar colors, similar packaging, similar slogans, similar music, and sometimes the same celebrity. Now the consumer sees product B but remembers product A. That's the fundamental regulatory concern. And importantly, India does not simply look at the name printed on the packet. The consumer protection framework specifically prohibits surrogate or indirect advertisements that circumvent restrictions on advertising prohibited goods in our country. So the legal question isn't merely, does the advertisement say pan masala or not? It is, what is the advertisement actually communicating to the consumers? Let's answer the question. Why does India ban these advertisements in the first place? Because advertising doesn't merely sell products. It creates brand memory. Suppose a tobacco company spends 100 crores making a particular brand famous. Then the government bans tobacco advertising. The company can simply spend another 100 crore advertising an unrelated product carrying exactly the same brand identity. The advertising ban can become meaningless. The consumer may not even consciously distinguish the two. And this is particularly important for products such as tobacco because public health consequences of these kind of products are enormous. Say according to India's Global Adult Tobacco Survey 2016 to 2017, 21.4% of adults aged 15 plus were current users of smokeless tobacco. Approximately 24.2 crore people by the survey's population estimates. 24.2 crore people are consuming tobacco in our country, and Maharashtra itself recorded 24.4% of prevalence of current smokeless tobacco use amongst adults in the survey. So this isn't simply about whether someone likes an advertisement. It is about whether advertising can help maintain demand for products associated with serious health risks. See, let's go back in time. The modern story begins with the Cigarettes and Other Tobacco Products Act of 2003, COTPA. Now, Section 5 is very crucial. It prohibits advertising cigarettes and other tobacco products. But notice the wording. It doesn't merely prohibit advertisement showing a cigarette packet. It also prohibits participation in advertisements that directly or indirectly suggests or promote the use of consumption of tobacco products. Now that word indirectly is extremely important because without it, companies could simply redesign their advertising strategy, and that's exactly the loophole regulators worry about. See, the tobacco advertising prohibition became operational in 2004, but almost immediately, the industry faced a new question. What if you don't advertise tobacco? What if you advertise something else? This is where brand extension and surrogate advertising becomes difficult to separate. Suppose a tobacco company genuinely sells cardamom. It is perfectly legitimate to advertise cardamom. But suppose the cardamom product barely exists commercially while the tobacco brand is enormously famous, then suddenly the company launches a huge advertising campaign featuring India's biggest celebrities. The regulator has to ask, is this actually a cardamom campaign, or is cardamom merely the legal vehicle for keeping the prohibited brand visible? That is the problem India has been trying to solve for 2 decades. Okay, then now comes another important development. The Food Safety and Standards Act of 2006 and regulations made under it became central to the regulation of gutka and pan masala containing tobacco or nicotine. The 2011 Food Safety Regulation prohibited tobacco and nicotine from being used as ingredients in food products. It explicitly prohibited it. The Union government subsequently clarified that gutka containing tobacco and nicotine could not legally be manufactured or sold under this framework, and Maharashtra became one of the states enforcing these restrictions. Now, in July 2012, Maharashtra's Food Safety Commissioner issued an order prohibiting manufacture, storage, distribution, and the sale of gutka and pan masala containing tobacco and or nicotine amongst other prohibited ingredients. Now, the Bombay High Court upheld the regulatory action. See, this is important for today's controversy because the Maharashtra FDA isn't operating in a legal vacuum. It has a statutory public health framework under which it can act against misleading food advertisements and prohibited products. Now, the Supreme Court has also dealt with a broader problem. Now, in litigation concerning tobacco and pan masala, the court noted evidence that after advertising restrictions, manufacturers could attempt to circumvent the ban by promoting tobacco-free pan masala or use other strategies to maintain brand visibility. The court has recognized the public health consequence of pan masala and tobacco consumption and the importance of enforcing the prohibition on tobacco, nicotine in such products. This tells us something very, very important. See, surrogate advertising is not a new problem created by Instagram. India has been fighting this problem for decades now. What has changed is the sophistication of the marketing, please remember. See, now let's come to the year 2018. The Food Safety and Standards Advertising and Claims Regulation 2018. Now, these regulations require food advertisements and claims to be truthful, unambiguous, meaningful, and non-misleading. Section 24 of the FSS Act itself says that no advertisement of food should be misleading or deceptive or contravene the Act and its regulations. See, so now India has multiple regulatory layers. One is COTPA, then for tobacco advertising, FSS Act or FSSAI for food safety and misleading food advertisements, Consumer Protection Act for misleading advertisements and endorsements, then ASCI, self-advertising, self-regulation. Now, all this structure creates a very fascinating question. Who actually regulates an advertisement? The answer is sometimes there's several regulators at once and sometimes very few. So you need to understand one thing. Celebrities are no longer just faces. And this is where our Bollywood stars enter the story. Under the Consumer Protection Act of 2019, the Central Consumer Protection Authority CCPA can act against misleading advertisements. Section 21 gives the CCPA powers to direct discontinuation or modification of a misleading advertisement. Now it can impose a penalty of up to 10 lakh on a manufacturer or endorser for the first contravention and up to 50 lakh for subsequent contraventions. And then in 2022, the government issued the guidelines for prevention of misleading advertisements and endorsements for misleading advertisements. See, the underlying principle is important. A celebrity is not necessarily shielded simply because I was only the face of the advertisement. Endorsers have responsibilities. They are expected to undertake due diligence regarding claims they endorse. And ASCI's current guidance goes even further for celebrities. Celebrities should not participate in advertisements for products whose advertising is prohibited or restricted by law. This is one recommendation which has already been given and issued to the celebrities of our country. Now we reach the hardest part now. Suppose Vimal really sells Elaichi and consumers really buy it. Shouldn't Vimal be allowed to advertise its legal product? Yes, otherwise the law would become absurd. A company could potentially be prevented from advertising a perfectly legal product merely because the same brand name exists in another restricted product. That's why regulators distinguish between genuine brand extension and surrogate advertising. See, ASCI had developed objective criteria to help determine whether a brand extension is genuine. For example, its guidelines consider whether the product is registered with the appropriate authority, whether it has meaningful sales turnover and whether the scale of advertising is proportional to the product's actual business. Now, for an established brand extension, see, ASCI's criteria include sales of at least 5 crore annually, nationally, or 1 crore per state where distribution is established. Now, the question is why? Because imagine a product that generates 20 lakh in annual sale, but suddenly receives a 100 crore celebrity advertising campaign. That raises an obvious question. Is the company really trying to sell the product, or the product merely being used as a legal cover for advertising the restricted brand? See, now let us look at the Vimal case. And this brings us back to August 2026. Maharashtra's FDA has issued notices to Shah Rukh Khan, Ajay Devgn and Tiger Shroff over Vimal Elaichi's advertisements. Now, the regulator alleges that the advertising amounts to surrogate promotion of Vimal Pan Masala. Now, the notices reportedly seek explanations and a removal of promotional material from the social media. But here's the crucial journalistic distinction. A show cause notice is not a conviction. The regulator has made an allegation. The actors now have an opportunity to respond. So the responsible way to describe the story is that FDA alleges surrogate advertising, not the actors illegally advertised tobacco. That distinction matters a lot. Now ask yourself, why do companies spend enormous amount of money hiring celebrities? Because celebrities transfer something extremely valuable, that is trust and memory. Now if you see an unknown person saying, try brand X, you may forget it. But if Shah Rukh Khan says Vimal, the brand becomes associated with one of India's most recognizable personalities. And this creates what economists and marketeers called brand equity. Now the value of a brand isn't merely the product inside the packet. It is recognition, association, recall, prestige, and emotional connection. Therefore, even if today the advertisement technically shows Elaichi, the consumer may remember Vimal. And this is precisely why surrogate advertising can undermine the advertising ban without explicitly showing the prohibited product. See, but now we encounter an interesting paradox. India wants to protect consumers, India wants to prevent tobacco promotion, but India also wants freedom of trade, legitimate brand advertising, and freedom of commercial expression. So imagine two companies. Company A generally sells cardamom. It has 100 crore of annual cardamom sales. It spends 5 crore advertising it. Company B has a famous tobacco brand. It launches a tiny cardamom product. Its sales are negligible, but suddenly it spends 100 crores advertising that cardamom brand with Bollywood stars. Treating these two companies identically would make little regulatory sense. The challenge is therefore not ban brand extensions. It is identify when a brand extension is genuinely and when it is merely a disguise. Now, here's where the story becomes much bigger. India has laws, India has regulations, India has CCPA, India has FSSAI, India has ASCI, India has state food safety commissioners, India has COTPA. So the problem isn't necessarily the absence of rules. The problem is enforcement. An advertisement can appear on television, YouTube, Instagram, X, OTT platforms, billboards, events, sports sponsorships and influencer pages. A regulatory system designed around television and print now has to operate in a world where one Instagram post can reach millions within hours. And there is another problem. The law often reacts after the advertisement has already achieved its objective. See, by the time a regulator issues a notice, the brand may already have gained millions of impressions. And this is exactly the reason the debate cannot stop at should Shah Rukh Khan endorse Vimal. The larger question is, what kind of advertising environment should India create around addictive or harmful products, or as we call it as sin goods? India has made substantial progress in tobacco control, but the scale of tobacco use remains significant. See, again, the GATS 2016-17 surely found 28.6% of Indian adults currently using tobacco, combining smoked and smokeless tobacco. And amongst adults who use smokeless tobacco, 95.6% believe that smokeless tobacco causes serious illness. That statistic is fascinating. People can understand the health risk and still consume the product, which means regulations cannot rely only on consumer awareness. The environment in which products are marketed matters a lot. So then the question is, what should India do? And what would be a better system? See, first, follow the money. If a company claims to be advertising Elaichi, the regulator should imagine how much Elaichi does it actually sell? Where is it sold? How much does it spend advertising it? Is the advertising proportionate to its sales? This is what needs to be studied. Second, follow the brand. Does the advertisement use the same logo, the same colors, the same slogan, the same celebrity, the same music, the same visual identity if element points out towards restricted products, calling it elaichi advertising becomes harder to defend. And then is the third one, regulated digital advertising. The same standards should apply to television, YouTube, Instagram, influencer marketing, and sponsored posts. And the fourth point is, make celebrity due diligence real. If a celebrity earns crores endorsing a brands or products, I don't know why they should not automatically end the inquiry. But neither should celebrity involvement automatically establish liability. There should be a clear, predictable due diligence standard. And the fifth point is speed. The regulator's response should happen while the campaign is running, not months or years later. Now, the question India really needs to answer, what is this entire controversy really about? It's not about Shah Rukh Khan, it's not about Ajay Devgn, not about Tiger Shroff, not even about Vimal. The deeper issue is, what happens when a regulation bans a product but doesn't ban its brand? Because in the modern economy, brands can become more powerful than individual products. A tobacco product can disappear from an advertisement, while its logo, color, celebrity, music, slogan, and identity continue living in the consumer's mind. That is a fundamental challenge of surrogate advertising. India has spent more than 2 decades building a regulatory framework around tobacco advertising. COTPA in 2003, advertising restrictions from 2004, food safety restrictions in 2011, state-level enforcement against gutka and tobacco containing pan masala, FSSAI's advertising framework in 2018, Consumer Protection Act in 2019, CCPA's misleading advertising or advertisement guidelines in 2020, and now a new test in 2026. Can the law distinguish between a genuine legal product and cleverly distinguished advertisement from an illegal or restricted one? That is going to become increasingly important, because tomorrow the product may not be elaichi, it could be anything. And the advertisement may not even be on television, it may be on phone. So the real question isn't, is this an advertisement for elaichi? The real question is, what does the consumer actually remembers after seeing it? Because if the answer is a banned product, then perhaps the advertisement never really was about elaichi in the first place. And that is the paradox of surrogate advertising. I hope you gained a new perspective from this session. Do let me know what are your views regarding it. All the very best. Have a beautiful day. Thank you.